regulation in redistricting by declining to rein in this most egregious example. The vote dilution test presented to this court today is a limited and precise test designed only to impose liability on the worst of the worst cases, thus limiting the number of partisan gerrymandering cases that this court will see. And under this very limited and precise vote dilution test, a lower court will apply a three-pronged test where all three prongs must be satisfied. And under many of those prongs, there are multiple screens to limit the number of plans subject to liability. First, partisan intent has to be proven on a district-specific basis. That is, proving that district lines were drawn to subordinate the adherents of one political party and entrench the power of the party drawing the lines. Second, partisan effect has to be shown at the district-specific and plan-wide levels. The district-specific effect inquiry looks at intentional cracking and packing of Democratic clusters or Republican clusters, as it will, and the statewide, the plan-wide inquiry is whether the map as a whole creates a severe and durable effect on the disfavored party. Then finally, the court asks whether there's any justification at the district-specific level for the cracking and packing observed, and whether plan-wide, the map as a whole is more biased than you would expect, given the state's political geography and use of legitimate, non-discriminatory criteria.
But do you deny that built into this is the idea that we should at least have proportional representation light? Proportional representation is in a sense that it is in some way the baseline against which all of this is measured.
Not at all, Justice Alito. With the three prongs, there is plenty of room for non-proportional plans.
A degree. I mean, you don't have to have strict proportional representation, but that's the baseline. That's what you're measuring. Was there a partisan effect? Well, there's a partisan effect because it deviates from some notion of proportional representation.
The effects prong and the justification prong do real work to prevent that situation from happening, from this being just a measurement from the deviation.
Well, how can that be? Because I would have thought under the effects prong there has to be at least some effect, right?
There has to be a district-specific and severe and durable statewide.
I got it. So we have to measure effect from what? So every test that's been presented to this court, last year and this year, we talked a lot about last year, the efficiency gap, which is how far a deviation from proportional representation. And we were told, I think 6 or 7% of deviation would be okay, and that would not be an untoward effect. But anything above 6 or 7%. Today we're talking about 2/3 as an effect. We need to have a number or some formula to determine what effect is enough to state a claim and what isn't. Otherwise, every case is going to come to this court. And I'm still waiting to hear what that number, what that formula might be, other than proportional representation. And we're not going to tell you today just how far deviation would be permissible, because that would expose the problem.
Several points in response, Justice Gorsuch. The legal standard in question is severe and durable effect. All of the social science is just an evidentiary tool, not a legal tool. Two categories of social science evidence were brought to bear on this question of severe and durable effect. The simulations didn't set a numerical threshold baseline because you see a range of produced plans with varying Democrat-Republican splits using these simulations, and we're giving the legislature's breathing room. All of the simulations produced at UCUR.
With respect, counsel, I'm sorry to interrupt, but breathing room from what?
Breathing room
from how much breathing room? From what standard? And isn't the answer that I understand you don't want to give it, but isn't the real answer here breathing room from proportional representation up to maybe 7%?
No.
If it's not that, then what is this breathing room, and where does it exist?
Breathing room exists in the bell curve of expected and reasonable map allocations of representation. It's breathing room to employ some political consideration.
Why isn't the answer to Justice Gorsuch's question that what's not allowed is deviation from whatever the state would have come up with absent these partisan considerations. In other words, the state can do whatever it wants. It can depart from proportional representation however much it wants to, however much the natural features of the state would suggest. It can come up with something that's not proportional representation at all. What it can't do is deviate from that based on partisan considerations. Isn't that what this test is essentially driving at?
That gets at the effects prong. I think that's
Yes,
a great
that's what I was talking
encapsulation. But
about.
you would still potentially lack discriminatory effect. And it really is a question of whether the line drawing party is imposing upon a disfavored party a severe and durable effect. That's the
Counsel, I get that. You've wisely adopted a very fine answer given for you. But I guess my question is, once we control for geography, once we control for all those things, we're going to have hundreds and hundreds of maps, as Justice Alito has pointed out. Computers spit them out infinitely now. And once we say, okay, all these other factors are controlled for, we can do a regression analysis, control for geography and all these things. We're still going to have hundreds of maps. And the legislature is going to choose one. And at that point, we have to say, what's the range of permissible options? And from that, we need a baseline. And the baseline, I still think, if it's not proportional representation, what is the baseline that you would have us use?
There is
controlling for geography and everything else.
Well, the geography is baked into that bell curve.
It's baked in, I accept that. We agree on that. You and I actually agree on that. So after that, when we're left with, we've thrown out millions of maps, we're only left with a mere few thousand. Okay, what deviation from what to what?
If what we're left with is no extreme statistical outlier or no grossly asymmetrical map, the legislature can choose from any of those plans.
Counsel, what is wrong with proportional representation?
There are certainly states where the natural geography of the state doesn't lend itself to proportional representation. We live in a system with single member.
If you were cracking or packing to get to proportional representation, would that, in your view, be unconstitutional?
This court has endorsed that kind of activity in Gaffney, where a legislature is striving for proportional representation. Our test would not invalidate a plan like Gaffney because it would not have a statewide severe and durable effect, and it would be something that you would be within the...
Agree with Mr. Clement that the Constitution does not require proportional representation or require
something close to proportional representation.
The Constitution does not require it. But what we see here in this test that we've employed, Justice Roberts, to get to one of your earlier questions, is a test that employs a durability inquiry and sensitivity testing, technology that was not in existence in Veith and Vandermeer and the Republican judge's case in the 1990s, and that map drawers are using right now. If there is a plan where under any plausible shift of voter sentiment, the bias across the plan would disappear, that plan would not be unconstitutional. Again, this is an enormous screen to the kinds of plans that would be subject to liability. Our proposed test, the one adopted by the district court, is so exacting that it narrows dramatically the number of plans subject to scrutiny and leaves legislatures lots of breathing room. And
am I right to understand that your test allows a greater degree of partisanship in redistricting than Mr. Bondurant's?
I think they're complementary tests depending on how you understand the constitutional harm. Where we see the vote dilution tests based on the one vote and the racial vote dilution frameworks, we see those tests as allowing room for some political considerations, particularly the ones endorsed by this court. But it's just a different approach to the same problem. We do believe that our test is narrow and descriptive enough that it gives legislatures guidance on what to do to make sure that they stay on the right side of the Constitution, and gives lower courts something very manageable to apply and to grapple with, and that the pleading standards are going to be very high. To prove a severe and durable effect is not to just allege it, it's to come forward with rigorous statistical evidence that supports this situation.
I took some of your argument in the briefs and the amicus briefs to be that extreme partisan gerrymandering is a real problem for our democracy, and I'm not going to dispute that, and that the court, even though it might be a problem to get involved in all these cases, should, in essence, recognize the emergency situation from your perspective. But what about, to pick up on something Justice Gorsuch said earlier, that there is a fair amount of activity going on in the states on redistricting and attention in Congress and in state Supreme Courts? In other words, have we reached the moment, even though it would be have we really reached the moment, even though it would be a big lift for this court to get involved, where the other actors can't do it?
The North Carolinian plaintiffs in front of you can do nothing to solve this problem. But
I'm thinking about more nationally. The amicus briefs are certainly referencing a problem in many states. And the idea, I think, in the briefs is this court and this court alone can step in. And there is a fair amount of activity going on in the states, recognizing the same problem that you're recognizing.
And as Mr. Bonder acknowledged, east of the Mississippi, there's a very small number of states where this is a possibility. This court has rightfully been concerned about the burden on the court and the reputation of the court.
That's on initiatives, right? And even there, New Jersey, Michigan, Ohio have dealt with this in some way, just to pick a few that I've got in front of me. But you also have the state Supreme Court option, as Justice Kavanaugh pointed out, and we often overlook that possibility in our federal system. What do we do about that?
Other options don't relieve this court of its duty to vindicate constitutional rights. And certainly while the reputation of the court as an independent check is an important consideration, understand that on the facts of this case, the reputational risk to the court of doing nothing, when David Lewis says, I'm going to draw a 10-3 plan, and if I could draw an 11-2 plan, I would, the reputational risk of doing something is much, much less than the reputational risk of doing nothing, which will be read as a green light for this kind of discriminatory rhetoric and manipulation in redistricting from here on out. This is a situation where, with all due respect, Justice Connor was not correct. This isn't self-correcting. Voters in North Carolina, no matter what level they turn out, this was a swing election in 2018 for North Carolina voters, and they were not able to eliminate the bias in the plans.